Mr. Smith, following up on Mr. Stubbe's question, I want to understand the precedent here. So if a candidate for federal office wanted to use campaign money now to make a hush money payment, could they point to what has occurred in this New York litigation and say, well, I guess I can go use my donor money to make a hush money payment?
I suppose they could, at least unless Judge Jackson is correct, and we'll have to wait for that overturning on appeal. But yes, that's...
Yeah, but well, I guess I want to ask the question, if an appellate court does not in some way deal with what has been laid before the country, could we see people collecting money from donors, lobbyists, and PACs, and then using it to make hush money payments?
Yeah, and you could do almost anything else. You could say, for example, I'd really like to go to the Super Bowl this year. Think I'll take a couple of donors along and buy your Super Bowl tickets and your whole trip to the Super Bowl because it's for the purpose of influencing your campaign.
So in the prosecution to preserve our democracy, we have now greenlit potentially the most expansive abuses of campaign funds ever.
Well put.
So, all right, I have to test the limits of this. I do not like wearing ties. I would never wear a tie. I'm told that when people vote for a congressman, they like to see them wearing a tie in their advertisements. So does this now mean that when I go to Ross and buy a tie, that I should use my campaign credit card? Because otherwise, I'm not really a tie person?
If you took seriously the subjective standard that was given to the jury as the instruction, yes, it would mean that. If you took the objective standard that appears in the statute, no, you couldn't.
So in the absence of some appellate review here, and this is why we have appellate courts to try to resolve these things, do we not unleash like this confusion and then this opportunity for fraud? Because here's how this will go. Politicians will then simply use the gray area to enhance their own personal lifestyles through their campaign funds, right?
Yeah, that's correct. And one thing we should remember is that the Federal Election Campaign Act was elected or enacted against a background in which members could just pocket the campaign funds. And that was part of the whole idea, was you're not going to be able to do that anymore.
Well, thank goodness for the good prosecutors in New York who have unlocked the greatest potential for campaign fraud in the history of the campaign finance system. Judge Wilson, I just want to ask you a precise question. Was there ever a case that you were presiding over where you had a family member economically benefit from the notoriety of the case?
No, never.
You sure you don't want to take some more time on that? Think about it?
I don't need more time. I know that for a fact.
Well, I mean, if that had ever arisen, would you have allowed a family member to make money off the notoriety of a case?
I would have recused myself from the case.
Huh. Well, it's just interesting because we had Attorney General Garland who was, spent a good amount of time on the bench, and I asked him the same question, and, he said that he wouldn't answer it because it was obviously a reference to what had gone on in New York. I mean, I thought he might could have answered it, but, I mean, when you look at what happened in New York, does it concern you that the judge in that case seemed to have a family member who was economically leveraging the notoriety of the case?
It greatly concerned me, but not so much from the perspective of the ethical violation that would be apparent, because that judge did get an ethical opinion from the Judicial Ethics Committee in New York that exonerated him from any wrongdoing in listening to the case when his daughter was benefiting. What I was concerned about was the appearance of impropriety. When I sat on the bench, sometimes I would get a report from probation or some other organization, and they would hand it to me in an envelope. And I made certain to open up that envelope and show everybody that it was a report that I was looking at, because I didn't want there to be the appearance of impropriety that I'm receiving an envelope from someone in the courtroom. The concept is the same here. You're presiding over a case where your daughter is benefiting and where you've made political contributions in small amounts, but it's irrelevant, the amount. But you've made contributions to the political opponent of the defendant before you. These are the very essence of the appearance of impropriety, and I feel strongly that Judge Merchan should have recused himself on that basis.